Welcome once again to Lehto's Law. Here's Steve Lehto.
I've been aware of this controversy out of Tennessee now for a little while. Guy is walking around a piece of private property that he owns or his family owns, and he finds trail cameras on it that he did not place there. And they later discover they were placed there by agents of the state. Government workers put trail cameras on their property without their permission and without a warrant. And the question is, can government actors go onto your private property and place trail cameras or surveillance cameras out there without your permission? Would that not be a violation of, the Constitution with respect to unlawful searches and seizures? And one of the problems is a concept called the open fields doctrine, which comes into play here. We'll get to that. But this story recently came to a head in Tennessee, reported by agweb.com, which is the website of the Farm Journal. And Tom sent me this notice and said, Steve, check it out. Update here, brand new story. Game warden surveillance power on private property ruled unconstitutional in Tennessee. This will vary from state to state because this right here hinges apparently on the Tennessee state constitution, not the U.S. Constitution. Game wardens must have a warrant to conduct surveillance on private land and may not rely on the power of the federal open fields doctrine in Tennessee. On March 22nd of 2022, the Benton County Circuit Court declared trespassing and surveillance by Tennessee Wildlife Resources Agency personnel on private property illegal, according to the Tennessee Constitution. As a backdrop to this decision, Benton County landowners Terry Rainwaters and Hunter Hollingsworth sued after the TWRA disregarded no trespassing signs by entering and installing trail cameras on private farmland and hunting ground. Relying on the latitude of the federal open fields doctrine, TWRA contended its warrantless searches were permissible, but the circuit court ruled that the game warden's actions violated the Tennessee Constitution. So there's a state constitution and the federal constitution. And most people don't stop to think about whether the state constitution is narrower or broader with respect to what it allows. So in 1924, the U.S. Supreme Court set up the open fields framework and said the U.S. Constitution does not extend to most land. The special protection accorded by the Fourth Amendment to the people in their persons, houses, papers, and effects does not extend to open fields. Open fields. So let's suppose you have a house, and there's a little yard around your house, and then you got 20 acres of just land around your house, and let's say you farm some of it you left wild, and some of it you put in like a BMX track or something. They're saying in the open fields doctrine that these wide open spaces back here don't get the same protection that you personally get or that your house gets. And I think most people, when they hear that, they go, what? Really? That doesn't make any sense. Well, they were saying that the Fourth Amendment was more personal. Your person, house, papers, and effects sounds a little somehow contained, right? Well, at least it does to the Supreme Court. Significantly, open fields is translated beyond its literal sense and basically is defined as general acreage, woods, fields, farmland, barren ground, and more. And in 1984, the Supreme Court gave it even more power, saying open fields do not provide the setting for those intimate activities the amendment is intended to shelter from government interference or surveillance. There is no societal interest in protecting the privacy of those activities, such as the cultivation of crops that occur in open fields. And I disagree wholeheartedly 100% with that. And here's the problem. If you are a landowner in America, you own property, okay? It's something that many people aspire to. I would like to own some land, okay? So you own a piece of property. Let's say you live on the piece of property. Again, getting back to my example, 20 acres and a house, right? You get a house, you live there. You decide that you enjoy this 20 acres and you want to enjoy it for you, yourself, your invitees, your relatives, your friends, but you don't want strangers or the government wandering around out there. So you put no trespassing signs all the way around the edge. You sprinkle them liberally about, bright signs, no trespassing. Let's say you even put up some fences. You put up fences that you think deer can jump over, but they're designed to a person walking up goes, oh, there's a fence. Many states, a fence is equivalent to a no trespassing sign. Depends on the state you're in, and again, check your own state. But if you encounter a fence, most people recognize, oh, person who owns this property has made a conscious decision to keep me out. Now, if you said, Steve, a government agent is going to sit on the other side of your fence and look into your property and look while standing outside your property, got a problem with that? Well, I got a problem with it, but quite frankly, I don't think it's a violation of the Constitution just yet because they haven't intruded on my property. So there you go. Person jumps your fence, I think, well, they're trespassing. They've jumped my fence. They're trespassing. That right there is, boom, game over. Like they have violated the law because they've jumped the fence. They're trespassing. So if a government agent comes onto your property and installs a surveillance camera and then leaves your property, by definition, they trespassed to get there. And I would suggest that the government ought to have a search warrant or a warrant of some sort to allow them to trespass onto your property to do surveillance. Now, the placement of the camera, I think, is even another step removed. So simply jumping the fence and stepping a foot onto your property, I think that right there is a violation. It ought to be a violation of the Constitution, Bill of Rights. Placing a camera would be another violation. It's even more intrusive because you can place a trail camera, does one of many things. It can simply record everything that passes in front of it, video and still photography. Or you can also get them that immediately upload the images to the cloud and send a notice saying, hey, a new picture's been taken. So unbeknownst to you, someone trespassed on your property and placed a spying device. Now, I understand that most hunters and other landowners who use these aren't spying with them, but when the government puts one on your property, they are, by definition, spying on you. They've done it surreptitiously. They didn't tell you what was there. This guy's lucky he spotted them. So he spots the cameras there. What are they doing there? How long have they been there? And by the way, will he get in trouble for removing them? Aren't they abandoned on his property? I know how people reacted when they heard that the government can place a tracker on your car and the question about whether you can remove it or not. And the court actually said, yes, you can remove it. But someone places a surveillance camera on your property. Can you remove it? I would think you ought to be able to. So that's the open fields doctrine, which says that the United States Constitution does not prohibit them from surveilling open fields, the open fields doctrine. So the Institute for Justice, the people who do such fine work, spearheaded a lawsuit against the TWRA on behalf of the two men, Rainwaters and Hollingsworth. For too long, TWRA officers have treated private land like public property, entering without permission, spying on people without a warrant, and doing it all with no meaningful oversight, explains attorney Joshua Wyndham. The court's decision to declare TWRA's constant overreach and abuse of authority unconstitutional is restoring my faith in the justice system, says Hollingsworth. It is a great relief to have the court recognize that searching my property without permission and without a warrant was unconstitutional, said Rainwaters. It's even better to hear that the court doesn't believe anyone else in Tennessee should have their rights violated in the same way. Now, TWRA can appeal this, and they've got 30 days to file an appeal of right to the Tennessee Court of Appeals. Despite the circuit court's ruling, open fields power remains in place for federal officials, and the Rainwaters Hollingsworth case is the first major victory for the Institute for Justice's project on the Fourth Amendment. IJ is currently defending two Pennsylvania hunting clubs challenging warrantless searches of private property. But this does hinge, like I said, and it turns on the language in the Tennessee Constitution. So it's always a fun thing to go and read your state constitution, because you probably read your U.S. Constitution by now, I hope, at least once, and heard different bits and pieces about where things come from in the Constitution, Article 1, Article 2, Article 3, and so on, and the amendments there too. But the Michigan State Constitution, for instance, contains some interesting stuff, and most states do as well. And a lot of state constitutions were drafted so long after the U.S. Constitution that the people who drafted them got a chance to see problems that had arisen under the U.S. Constitution and said, oh, there's something we can resolve in our Constitution by drafting ours this way. And so the state of Michigan's Constitution, the most recent one, was adopted, I believe, in 1963. And so we had a long time. We had a mighty long time. We had a really long time to look at how the U.S. Constitution had played out over the years. And 1963 Michigan Constitution is therefore, at least at the time of the drafting, something that people thought, well, this is going to solve a lot of issues that we'd have otherwise. So Tom sent it to me. Thanks a lot. Farm Journal editors wrote the article, agweb.com, agweb.com. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Victory is having done your best. If you've done your best, you've won.